Well, good afternoon, everyone. Thank you very much for joining us today. The Arbitra seminar on reviewing the CrowdStrike incident earlier this year in July. Just a couple of housekeeping points to begin with. If you do have any questions as the panel is speaking, please place those into chat. I'll take a look at it and I'll try to ask the questions as the speakers are speaking rather than leaving it to the end of the session. That way we have the full hour and a half to explore this particular topic with the panel. So please feel free to send us your questions in chat. So again, thank you for joining us today. Thank you to the panel for joining us as well. We have experienced speakers from different parts of the industry that will shed some light on the technical aspects related to the CrowdStrike incident, as well as the legal, financial, and insurance side of the equation. It's quite a topic with a lot of complex issues, but we hope to actually discuss as many of those today as possible, not simply to analyze what happened in the CrowdStrike incident, but also to look at future situations and perhaps give you some tips as to how you or your clients might be able to deal with preparing for those in the future, because as we all know, it's the preparation for incidents like this that help to reduce the risk. And so hopefully we'll be able to provide you with some good tips today as well that you can go away with and apply. Perhaps I'll just start with myself. So I'm going to moderate the session for us today. My name is Wolfgang Kumberg. I am a full-time neutral arbitrator and mediator with Arbitra. But for the past 25 years before that, I was in-house counsel to Northrop Grumman Corporation. I was their international legal director, assistant general counsel, and I dealt with a lot of the international disputes that the company had. One of the key areas that Northrop was and is certainly involved in today is cybersecurity. We worked extensively with GCHQ here in the UK to harden the cyber resilience for key infrastructure. As we will get into more detail about the CrowdStrike incident, I'd just like to mention that it probably has been the largest IT outage that has been experienced by us to date, globally experienced by us to date. So it bears some analysis, both technically what happened so that we can learn from that in the future, but also looking at the various risks that have arisen out of it. The speakers today will analyze the legal risks, the insurance aspects of the CrowdStrike incident, and also what might be done to help deal with the potential claims that are arising out of the incident itself, and then what can be done to protect yourself from future incidents like this. So the first speaker I'd like to turn to is Elliot Rose to my right. Elliot has been with PA Consulting for 30 years. is a partner in their cybersecurity leadership team, provides advice and guidance to help organizations stay safe from cyber attack. He has been involved in a number of global cybersecurity legal cases and has a deep insight into how attackers target organizations and how such attacks can lead to major business disruption. He also works with regulators and lawmakers in their pursuit to make organizations and countries safer from cyber attack, including what they expect of organizations to prepare for cyber attacks in the future. He has also provided evidence to the Joint Parliamentary House of Lords Committee looking at the shortage of cybersecurity skills necessary to protect the UK infrastructure from cyber attack. So Elliot, perhaps just turning to you first with an important question, and that's how do organizations identify the next potential CrowdStrike, and how do we provide a better response?
Thank you very much, Wolf. I think when CrowdStrike first reared its head back in July, I first thought it's a cyber attack. It's just so widespread and so devastating at the time. But I think what we've seen is actually it's basically a poor update on some software which actually do provide cybersecurity defences. So actually it's an example, though, I think, of how a simple change can have a massive impact and disruption. And certainly we'll come on to it later on in terms of how people respond to that and how criminal actors view that and see it as an opportunity, I think. But I think it's worthwhile just reflecting on why CrowdStrike was such a big issue for some and not for others as well, because that's the other thing about this. You talk about disruption, it really impacted some firms but not others. CrowdStrike itself is a highly effective tool. It works on the endpoints of an organisation. To do that effectively, it has to have regular updates, almost in real time, to go out to those endpoints. And and the operating system itself that it works with, it actually has direct access to this. And so the fact is, the update files were released, and it was a simple error. If you look at it, it's basically the number of fields that are actually in the update file. There were 21. I think there were expected to be 20 fields in it. And of course, when this went out and got issued out at the operating system level, Microsoft machines at the time just basically blue screens. It was a blue screen of death. CrowdStrike very effectively issued another patch 78 minutes after the original issue occurred. But the problem was that people, because the problem that happened at the operating system level meant that Microsoft machines couldn't get online and couldn't access that patch to actually download it. So it actually required a lot of manual effort in a lot of organizations to try and actually get the files, to manually update the servers, to enable them to actually get back up and running again. There was also added complexity about a lot of software. Some software was protected with using BitLocker. Because the machines couldn't get on the internet, they couldn't access that information to get the actual machine up and running again, accessible. So you had this situation where it was a really compounding of errors upon errors and how things were set up that caused this major disruption in some organisations and not in others. And I think it really clearly shows us how vulnerable we can be if we don't understand what's in our supply chain, what's running and powering our digital enterprise or our economy and our organisations. I think, and it's interesting to see, as I've said, that some organisations are really affected and some weren't. And I won't name names, but it's well publicised. There are two big global airlines. One cancelled somewhere between 50 flights. The other had to cancel 7,000 flights. One, it took literally a day to get over the incident. The other one, it took over a week to get over the incident. And that organisation, the second order organisation, had lots of servers, apparently. So again, as I described, that manual process of getting back up to speed again, they had to go through an awful lot of work and manual work to try and do that. And apparently part of their crew tracking tool as well was also based on Microsoft. That they couldn't get up and running very quickly and rebuild again. So that was a real problematic thing for them. So it's an example of how it's hit some firms really badly and others not so badly. And again, down to in terms of how they've been architected, how they've been designed. And perhaps a little bit about doing that testing as well. So again, to what extent have organisations tested, their resilience, their operational resilience, to what extent have they thought about the scenarios, to what extent have they thought about people, processes, and technology aspects to it. So, and I think the other thing that at the moment is that the software community is looking at, and Microsoft, I know, had a session in Redmond a week or so ago. They're also looking at now how these very highly effective tools, which provide real-time protection of endpoints, should they be working at the operating system level, or should there be a different way of actually they operate with the Microsoft toolset itself. So there are things being thought about in that regard, but it's a trade-off because a lot of this software is issued, patches issued almost every day on a regular basis to protect the organisation. If you hold back and test those patches in a staging area, you're then leaving yourself vulnerable to cyber attack. So it has opened up a new debate in sort of software community about how these things should be deployed, how they should work. But taking it back a step and taking it back as an organisation, what should you do as organisations today? And what certainly from my point of view, what are clients thinking about? Well, as I said, one of the things we look at is operational resilience. We ask our clients to look at where in their supply chain, what third parties they're using, what are in the contracts, how are those QA processes being tested before software is released into them, and understanding if you're buying software from one organisation, what are the third-party components are in that software as well, which could bring you down in this way that we've seen. Second area I've talked about is maybe looking at staging areas. We certainly saw some of the attack not affecting organisations in different time zones because they were perhaps doing things in a later time frame, so that helped them around that as well. So, perhaps if it's a critical area of your business, maybe there's an area, as I say, putting greater network segmentation around that. Maybe there's a way of doing some sort of staging so you make sure as quickly as you can that what you're issuing out is not going to bring you down. Some organisations are now talking about whether they should have dual software. So obviously this didn't affect non-Microsoft organisations. So there is a thought going around is actually should we duplicate different types of software, different type of operating systems? But of course that's not without its cost, not easy to do. Other things, again, it's caused to raise questions. The architecture, as I mentioned, 40,000 servers, trying to rebuild those very quickly is very difficult. So thinking about whether that's the right architecture you've got in terms of resilience around that, rebuilding from it. And then fundamentally thinking about, if you're an organisation managing 40,000 servers, is that best you do in-house? Or again, should you look at using outsourcing, software as a service or backup as a service to provide you that extra resilience around that? Again, that's not without problems or issues around that, but it's certainly bringing into that question again. But I will say, you can't just outsource a risk. You can't say, well, because I've given it to a third party, it's up to them if it goes wrong, I'm going to come after them. So, clearly the regulations these days say you're jointly liable. And finally, the other thing I'll just say is, again, I've talked about resilience, about testing the scenarios. Just test, think about the different failure modes, the way things can be attacked. And people often think just about technology, but I think the lesson from this is it's not just about technology, as we've seen. When the technology fails, what's it mean for the people and what's it mean for the process? And we can see that way, that hasn't been, where that's come together as a perfect storm in a way, it's created huge disruption and delays to get things back up and running again.
Right. It's interesting from a risk analysis perspective. Obviously, the focus has always been on the cybersecurity side.
Yes.
And here the irony is that the very tool to protect you is the tool that brings you down.
That's right, yeah.
And I'm sure most companies never really looked at that particular risk factor.
That's right. But it has made them think about that could have been a cyber attack, and that's the damage it could have occurred.
Right. Well, that's a good lesson.
Yeah.
As well, yeah. So how do you think regulators are going to respond to this? Do you think regulators will get more involved in regulating the area?
We're already seeing that in different areas. In financial services, the FCA have got their operational resilience initiative coming out in March of next year. That clearly states that organisations, it's a responsibility of that organisation to make sure they've identified their important business services, ways in which they can be taken down and ways in which they can rebuild them and get going again. And that has to be signed off by the board. So, and that's got teeth in terms of that new regulation coming through. So we're already seeing that. And I suspect other regulators, other sectors will start to do that and look at it. We've also seen some of the Network Information Systems Directive, and there's 2 directives that's come out that has teeth in terms of significant fines, 2% of global turnover, or up to 10 million euros per incident. And that is looking at operators as central services. And it used to be, the very sort of nuclear operators and things like that, very critical. But it's wide now. Because we're so digitally enabled now, it covers off things like food manufacturing, for example. And so under those regulations, again, a little bit like what the FCA have been doing, it puts the onus back on organisations to make sure they thought through how they could be brought down or have issues. They have to look at how you recover from that. And again, must have board level responsibility around that. So that's important, we're seeing that. I think from the CrowdStrike incident, it's certainly we've seen that in the US. So George Kurtz, the CEO of CrowdStrike, has been summoned to testify before US Congress. So that the US Congress has taken an interest in this now as well to look at what's happening there. And we certainly see the Department of Homeland Security in the US are hinting that they might launch investigation around this as well. So there'll be things that come out from that. But I think, as you see, from regulators who feel the responsibility as we become more critically dependent on digital, plus the focus around it, making sure we're operating as countries and organisations, then we'll see more regulation, I think, more lawmaking coming to the table on that.
Right, right. Well, that's actually very, very interesting. I mean, just looking at it from a CrowdStrike perspective, so you're the software developer and you're issuing these patches all the time. I mean, is there something specific that they might be doing to ensure that they don't have this kind of glitch?
Yeah, I mean, they've done obviously a deep dive investigation, as you'd expect, and they produced a report on it, which is available on their website, and clearly they've tightened up their QA processes and procedures to make sure that it doesn't happen again. And that's great, that's brilliant to see that they put in place, being responsible around that. But I think that's just an example of one thing. What else is there in your supply chain? What software do you use? What components, as I say, often you don't see the components that are behind it as well. So when you're looking at contracting organisations, really trying to understand the complexity, the building up of risk, and some of the solutions you're using, and then thinking about if they do go down, how do you cut back to a manual way of working? Do you need a backup as a service to actually cut over to actually then to keep you going?
Yeah, that's a good point. How about bad actors, criminals? Are they going to learn something from this?
Well, we've seen it already, and of course, bad actors and criminals love it when there's disruption like this. So there's been lots of fixed files being emailed around to organisations, which of course convey malware in it. So click on it, and you've suddenly got another problem on your hands. Right. There's lots of obviously impersonating CrowdStrike support helplines to actually get people to give over information and details. So it's certainly created that interest around that from that point, as we've seen, that often happens in these events. But also, I think just as we're learning from it, they'll be learning from this and saying, actually, this is an interesting new angle in terms of how you can attack people. And I know you've talked about CrowdStrike, have done a detailed analysis of it, put in place security procedures and processes around that going forwards. But again, we should all be thinking about that longer supply chain, delving into understanding how robust is it, how secure is it in terms of underpinning our operations today.
Great. Yeah. Well, I mean, that's an important lesson for us, but as you say, the bad guys, they also will learn from it. Yeah. Take advantage of it. Very interesting indeed. All right. Well, we're going to turn now to perhaps the legal landscape, because coming out of that, there are a lot of questions that arise then with respect to liability. And we've already heard from Elliot that there are a couple of airlines that were affected, but in fact, there's a lot of critical infrastructure that was affected. Hospitals in particular were also affected by this globally. So a lot of potential liability there. So we're lucky to have with us today Joanna Elieli, and she's going to look at the legal aspects of this for us. Joanne is a litigation partner in Stevenson Harwood here in their London office, and is the firm's cyber lead, specializing in complex cyber data and technology-related disputes and investigations. She has a wealth of experience in providing clients with strategic advice in relation to data breaches and cyber incidents, and in handling associated follow-on litigation. In particular, she is regularly involved in defending claims brought in relation to alleged breaches or infringement of data protection laws. So right there, alleged breaches is right on point, I think. So maybe starting with an obvious question, but a difficult one. What sorts of claims might companies be exposed to from others as a result of this incident? And what sorts of claims might they have available to them against others? So where are they vulnerable, and where might they be able to make a claim, Joanne?
Yeah, thanks, Wolf, and it's great to be here to be able to discuss this today. I mean, this question is something that we get asked a lot when clients are impacted by an IT outage or by a cyber incident, and the sorts of risks of costs that are associated with claims like this is often really front of mind for clients when they're going through these sorts of crises, and business leaders are obviously very preoccupied with these questions at times like this. Generally, the way I look at it is these sorts of claims tend to fall into one of three buckets, two of which are quite obvious ones, one of which I'll come to at the end is rather less obvious. But first of all, there are those contractual claims that companies who are impacted by the outage might be exposed to themselves. So these are effectively the incoming claims that are coming from third parties, where the company would be the defendant in that situation. Now, these claims are most likely to come from the company's own customer base, so whether that's individuals or whether it's other companies or businesses that they've contracted with. And the claim is usually centred around some sort of allegation relating to breach of contract. Now, again, generally speaking, what we tend to see here is that that claim will likely be related to a failure to deliver some sort of product or a service, or some sort of delay in the delivery of that product or service. And so what's important here is that those customers will need to be able to show that a breach of the contract has actually happened, as well as being able to show that they've suffered some sort of loss as a result of that alleged breach relating to the outage. Now, the nature of that loss is going to be really important in any situation like this, because it must be a type that's permitted under the contract. And we'll touch on that a little bit more later, but often that's really the crucial nub of the issue is this a sort of loss that the contract envisaged, and is there anything preventing a customer from being able to claim for that? Now, whether any claim against the company will succeed will very much depend on those contractual terms, as I mentioned. And at a high level, there are three key things that we tend to advise clients in respect of that are really relevant to those considerations in the context of an IT outage. So the first of those is the company's specific contractual obligations and whether it failed to meet those as a matter of fact. And that's something that's going to turn depending on the specifics of the situation. I mean, the CrowdStrike outage affected a whole range of different companies globally. And so the fact-specific circumstances is going to differ so massively from company to company, depending on how that impacted the business at a service level. The second thing that we advise clients to look at is whether there are any force majeure provisions in place in the contract. Do those exist? And if yes, can the company rely on those to excuse itself from the liability that may flow from any failure to perform those services? And finally, are there any liability caps or exclusions that the company can rely on, even in circumstances where it does seem likely that there has been some sort of breach and that those losses are rightly claimable under the contract? Right. So that's the first claim option.
Right.
The second type of claims then are those that are available to the impacted company themselves against other companies. So those are the potential outgoing claims, and this is a situation where the company would be the claimant in that circumstance.
Right.
So this is going to be most relevant in circumstances where the company impacted in this circumstance by the CrowdStrike outage was an intermediate party. So take, for example, you have a company that's one of many in a layer of the IT ecosystem. So there are contracting parties above them and there are contracting parties below them. They don't necessarily have contractual arrangements in place with the ultimate affected party, which is CrowdStrike in this instance. They've got various contractual arrangements both above and below them in the supply chain. Now, again, all those same considerations that we've just talked about will apply equally in these circumstances here. And again, it will all be very dependent on the contractual terms that the parties have entered into. But what I will say, though, is that direct claims against CrowdStrike itself as the ultimate liable entity are pretty likely to be unavailable for most companies that have been impacted by the CrowdStrike outage, because the vast majority of these companies just don't have a direct contractual relationship with CrowdStrike. So instead, what they need to do is look at the contractual relationships that they do have and see whether there are provisions that they can rely on in those contractual arrangements. It's also going to be inherently unlikely that the vast majority of those who've been indirectly affected by the outage, so let's take, for example, people whose travel plans were really heavily disrupted, using the airline example of earlier. Now, the likelihood of them being able to bring a claim for the losses that they've suffered is going to be quite difficult for all sorts of reasons, including that point about lack of contractual relationship, but also the foreseeability of the loss is something that needs to be taken into account as well. So for those companies that were impacted by the IT disruption themselves, but don't contract with CrowdStrike directly, really their best option is likely to be against the provider of the IT services that they've contracted with. By far and away, that's likely to be the most effective route for recovering any of those losses, obviously outside of the insurance position, which I know Frank's going to talk about later. But again, for any claim to succeed, the company making it will need to show that they have in fact suffered loss. It's no good that there was just disruption. You have to be able to show that loss has actually flowed from that and there are damages that need to be recovered. So often this will be things like lost revenue due to operational issues as a result of the outage. But there are various practical considerations that should be thought about, whether you're either the claimant party or the defendant party in either of these situations. And the first of those is the documentation of any losses. If you're the claimant company, you need to make sure that the minute you started incurring any losses, you've documented them as clearly as possible. And if you're the defendant company, you want to be asking for a record of those losses that the claimant's documented as soon as possible, so that you can really see what you're dealing with as an immediate practical step. But then looking beyond just the potential claims, it's generally fair to assume that the primary interest in most situations like this, where it is an IT outage and where it isn't a cyber attack, is going to be in minimising further disruption. And that strongly points in circumstances like this to maintaining existing relationships wherever possible. And obviously litigation in any circumstances can be disruptive, it can be time consuming, it can be really expensive. And often it can have a very damaging impact on the relationships that you have with those above and below you in the IT ecosystem. And so on a practical level, with commercial considerations front of mind, we really encourage our clients to think carefully about whether initiating claims against those contracting parties, who are often play an integral role in the maintenance of your business operations on a daily basis. Is that something you want to be engaging in? Is there a way that you can work with them to try and find a better resolution to those before we start getting down the litigation route? And then finally, the third type of claim that I wanted to touch on, and this is one that I think is very often overlooked, but is arguably the most important one of all, I think, particularly from a firm culture perspective. And that's the risk of claims coming from within your own organisation, within the company itself. And what I'm talking about here is the risk of employment claims arising. Now, this might not seem like a particularly high risk on first blush when you think about it, but if you stop and consider how many IT and information governance employees work around the clock to deal with instances like this, whether it is a malicious attack or whether it's an inadvertent outage, you can see how easy it could be for employees within the company to really burn out, to have grievances, or even in the worst case scenario to choose to step away from the business as a result of those issues. And I think we need to not forget as well that for many employees in the IT and the information governance teams, a situation like this is their worst nightmare. It's what they plan for, it's what they prepare for, and it really is kind of the worst case scenario come true. And so what happens in these situations is often there is very high stress levels within teams. A lot of pressure are put on those teams to fix things rapidly, to work around the clock. And I think for senior team members like CISOs and CIOs, they can feel a very real sense of responsibility for what has happened, even when it's something that was totally out of their control, like this instance here. So all of that really is to say, look after your people in times like this. They really are the company's greatest asset and often are the quickest fix to resolving the issues that are going on and to get your company operational and running again. And so business leaders really need to be doing all that they can in times of crisis like this to look after those teams in particular, not just because it minimises the risk of claims to the company from within the organisation, but just generally because it's the right thing to do.
Right, yeah, very interesting. That last point is one I probably wouldn't have thought of, but it clearly is one that is a potential, and those types of claims, of course, arise. So, what's interesting, if there were that type of claim and there were the possibility of money being paid out to those employees, might that then be a claim if you had a contractual relationship with CrowdStrike?
Yeah, good question. That's actually not an aspect that I've considered in detail, but I'm sure, again, that would probably turn, as always, a typical lawyer's answer would turn on the
Right.
terms of the contract, but
Right, yeah.
certainly something that could be included.
Maybe just digging a little bit more into force majeure, I think a lot of people have come across force majeure now, particularly because of the COVID situation that we went through and everybody was scrambling to look at force majeure. It was sort of always a standard in all contracts, but nobody paid that much attention to the clauses. What would you be looking for in a force majeure clause? Because again, they come in different types and sizes. To be able to protect yourself or to bring a claim where there is a force majeure clause. What are we looking at?
Yeah, and again, these clauses are not a one-size-fits-all type of clause, and you do see them vary massively from contract to contract. And I think, as you say, well, particularly after COVID, these are becoming clauses that are being a lot more hotly negotiated now than perhaps they were before. I think previously we were seeing very standard terms be put in, and actually people are paying a lot more attention to them now for all the reasons you've just said. I mean, the general principle of a force majeure clause at a very high level is that it has the effect of varying the obligations of the parties in a contract in the event that certain events take place. Now, if that force majeure clause is to take effect, then generally it means that parties are no longer liable to one another for any failure to perform obligations, whether that be delivery of products or services under the contract, where that failure to perform is due to the force majeure event. And I think that end bit is the really crucial bit. Now, generally the events need to be specific. They have to be named as such in the contract in very specific terms. And so that often is an area that companies can fall down on. We see some very broad definitions making their way into force majeure clauses, and the reality is that if you have something that is unexpected and doesn't appear to be caught by that clause, then very often they will fall outside of it. The event also has to be outside the reasonable control of the party seeking to be relieved of its obligations. It's no good saying, well, we predicted that we were going to be useless in delivering this service, so we carved it out of the contract and now we don't have any liability to you. It has to be something that's outside the control of that party. And then finally, that event has to be solely responsible for that party not performing its obligations. So if there's something else that the party did that was within its control that also affected the non-performance, then generally this would point away from the force majeure clause being operative. Now, touching on where we started, because force majeure is a contractual concept, it's really highly contract specific in terms of how it will operate. And so, things like what will constitute the force majeure events, again, as we say, there's been much greater emphasis on that recently. But what will happen following a force majeure event? So to be effective, the contract needs to set out practical steps, what will happen in the event of these instances really clearly. So, for example, it might excuse specific instances of non-performance. It might extend deadlines for performance. It could suspend all obligations of all the parties to the contract until that force majeure event has ended. Or it might even allow complete termination of the contract. So again, very specific as to what the contract says, and interesting to see how those would operate in the circumstances. I think the key question here, linking it back to CrowdStrike, is whether or not the CrowdStrike outage constitutes a force majeure event. May very well be the case in some contracts, but not in others. And I think what we're seeing, and certainly what I've seen in recent weeks looking into this question, is does the list of force majeure events in contracts include IT disruption? And if so, what really are the exact terms in which that relevant event is described? Because ultimately, as we know, the event wasn't a cyber breach and it wasn't an attack. And so you often see those sorts of instances where there's a malicious actor being carved out as a force majeure event. But ultimately, this was failed software that happened inadvertently. How many people would have foreseen that as an issue and really included that with the level of specificity that's needed in order for a force majeure clause to be operative? So far, I'm not seeing very many. So I think
they
that's
might
quite
in the
interesting.
future.
We may well after this, yes, and that's exactly right. I think, pre-COVID, how many clauses would we have seen that carved out a pandemic in specific terms? I think post CrowdStrike, we're going to start seeing instances like this be included more commonly at the contract negotiation stage.
Yeah. No, that's extremely helpful. You've talked a little bit about the difficulties that companies might encounter in demonstrating, quantifying their loss. I'm just interested in, Elliot had mentioned the two airlines and the differing impact that this had on those airlines. So you've got the one airline that had apparently a more robust system that was able to withstand this and get back on its feet fairly quickly. The other airline that faced a lot of difficulties in doing that. Now, let's just say potentially they had a claim against CrowdStrike. How might that differentiate then the ability of one to claim, full losses as opposed to the other one that might not have had that robust system?
Yeah, great question. And really what we're talking about here is mitigation, right?
Right.
So you've had potentially, one party that's mitigated its losses much better than another, arguably. And it's not always possible to prepare for that mitigation. But I do understand that one of the airlines in particular refused help that was being offered by CrowdStrike and by Microsoft and wanted to resolve the issue on its own. And ultimately that has led to much longer periods of recovery. And so obviously any increased costs or damages associated with that, there's going to be a big question mark over whether or not those are properly recoverable. I guess you never know the counterfactual. You don't know how long it would have taken them to get their systems back up and running. But they've certainly given the other side, if a claim is brought in respect of that airline, real cannon fodder to be able to argue that we shouldn't be paying for the vast majority of these at all, because if you'd only accepted our offer of support at the appropriate time, then you wouldn't have found yourself with anywhere near the level of damages that you're now claiming for. So that mitigation point, I think, is really key. And I should have mentioned that actually as part of the force majeure discussion as well, because some force majeure clauses require the party to do everything possible to avoid the event or the impact of the event really taking hold. And so failure to mitigate losses in that situation may mean that a force majeure clause doesn't take effect. But I mean, other difficulties that companies might encounter in really, demonstrating and quantifying their loss in circumstances like this also comes down to issues relating to remoteness. So it may be very difficult for companies to quantify those losses insofar as what those losses are, but also are they too remote, are they too far from the contractual breach? And so I'm sure there are bound to be numerous examples of that, the foreseeability of those losses. And then we've also got things like liability caps and exclusions that can appear in contracts. And so you may well have a company that has got losses that run into the millions, but if the value of the contract was £100,000, you often see limitation caps that cap liability for the service provider to the value of the contract itself. And so any losses above that 100k threshold may well not be recoverable in that situation, or may well be excluded under various exclusion clauses. So falling back on my caveat of earlier, it really does depend on what the terms of the contract says about how recoverable those losses will be.
Right, and I believe I read that CrowdStrike did have some limitations.
I'm sure they will have done,
in their contract, right? And is there any way around that? I mean, if a company has that and there's this kind of catastrophic failure,
again, it's really going to come down to what it is that the parties have negotiated from the outset. And I think it really does place a huge amount of emphasis on parties proactively to be thinking as wide-ranging as possible at the actual contractual negotiation stage, not to place more pressure on our advisory colleagues, but I think it really does place strong emphasis on negotiating those really good terms from the outset. But I think it also, moving on to the cyber piece as well, I think it really does mean that if you are one of those intermediary players that we talked about earlier, who's in the middle of the ecosystem with obligations above and below, to really make sure at the contractual stage that you're doing your due diligence on the companies that you're working with, that you're contracting with, because you can have your house in perfect order, but if the people above and below you and people within your supply chain don't, then your business can fall apart no matter how good your cybersecurity measures are,
Right.
you're very dependent on others who are in that same ecosystem.
Yeah, I mean, the other thing that I just recall, dealing with all these software contracts, I mean, a lot of them are just standard form contracts.
Yeah.
And, typically people would just look at them, accept them as they are, rather than negotiate them. Perhaps today they won't be quite as cavalier in doing that.
And I think what we tend to see is the very large corporates out there, they will have their standard contracts and they will very rarely deviate from them. They have the buying power, and so they're often the ones that will stand firm and say, no, these are our provisions, these are our caps, these are our exclusions, take it or leave it, we'll contract with somebody else if not you. If you're a smaller, mid-sized company, you often don't have the same power when it comes to negotiation. You can find yourself in a situation where you have very differing terms across all of your contracts. You have 200 parties you're contracting with, and all of your provisions can differ wildly.
Right.
And so I think, again, that's something that's really important to keep on top of. If you don't have the power to be able to control as much as you would like what goes into your contract, the thing you really need to be doing is tracking what is in all of them and having a contractual matrix so that when something like this happens, you know who your notification obligations are to, you know what the timeframes are, you're not going to come unstuck in that regard.
Yeah, that's very
Because
good.
you've put the work in up front to make sure that you're on top of everything.
Yeah, and that's a relatively simple thing to do, but I don't think that many companies actually do it. It's just put that matrix together. That's an excellent idea. Yeah, thank you, Joanne. Well, maybe we will move on, and if I could just remind everybody, if you do have questions, and this is obviously a topic that raises a lot of them, please do just put those questions into the chat, and we will deal with them as we go along. So please feel free to do that. All right, well, next, let's just shift the emphasis. So we've talked about the legal liability, and one way to mitigate often that liability is insurance. I mean, that's a traditional way of dealing with risk. And we've got Frank Latal with us, who has many years of experience in the insurance industry. I must say Frank is also a colleague of mine at Arbitra, so the two of us are both together in Arbitra. But Frank has spent his career in the world of commercial dispute resolution and global property and casualty insurance. He's managed and resolved disputes through trial, arbitration, mediation, and negotiation. He spent 14 years in private legal practice followed by 21 years as a senior corporate property and casualty insurance executive. Most recently, he served for 15 years as the chief claims officer for Chubb Group, the world's largest publicly traded property and casualty insurance company. In that role, Frank was the chief executive officer for a claim organization of 6,000 professionals operating in 54 countries that paid more than $16 billion annually in claims adjudication. He started a consulting and ADR practice after leaving Chubb, and as I say, he's a colleague of mine in Arbitra. Frank, first of all, I would say 6,000 people. I had to deal with hundreds, but never 6,000. That's quite a task, I must say.
Oh, they all didn't report to me, but they were,
yeah, but
they were in the
indirectly they were
right?
your responsibility, right? So that's already a big feat. Frank, just perhaps starting to look at the insurance side of this, because I think that does play a critical role, and many companies, feel reassured because they have insurance, but of course that will vary as to the effectiveness of that insurance. So, what role will insurance and insurance recoveries play in the CrowdStrike event?
Thanks, Wolf, and again, I'm happy to be here today. So insurance and insurance recoveries are going to play a role, but a limited and not an outsized role in this particular event. But I think the whole CrowdStrike event, along with some earlier events, one was called Change Healthcare and another CDK, are all going to focus on this concept of cyber insurance, which is basically, in the insurance industry, a newer product. So as with any significant event in the insurance industry, where policyholders are going to look to their insurer for potential recoveries, it's early days. There have been a lot of notices of claims that have been filed. There hasn't been a tremendous amount of claim payment activity, and that wouldn't be expected yet because it's a relatively new event. And policyholders are preparing proofs of loss, and policyholders who have potential third-party liability along the lines of what we were just talking about are just really sort of putting their cases together. So it really is early days when it comes to insurance. I said it's going to play a role, but not a significant role, for a couple of reasons. And both the major rating agencies, the major brokers, and many of the insurance sort of watchdogs out there have all opined that the monetary amount of insured losses for CrowdStrike overall will be just a fraction of the total economic loss out there. Why is that? I guess one reason is because, as I said, cyber insurance is basically a newer product when it comes to property and casualty insurance. And a lot of commercial businesses haven't purchased it. Another reason, I think, is there's no standard policy yet, and there are a lot of different language and different needs that are out there. I think the standard view on purchasing cyber insurance was to focus on malicious acts, was to focus on ransomware, was to focus on the bad actor. And as this was a systems failure event, there's going to be a different insurance coverage trigger for that. But as I said, I think the event is going to cause both policyholders who have cyber coverage and commercial businesses that hadn't purchased it. This event is going to cause them to look further as to what are the potential ways to shift risk by buying cyber insurance. For those policyholders that have purchased cyber coverage, I think the major focus will be on first-party business interruption coverage, coverage for economic loss as a result of the incident, and the policyholders will be checking to see whether their standalone cyber coverage, first of all, had a coverage trigger for systems failure as opposed to malicious acts. And then number two, some of the normal things that you would find in a first-party policy, like a waiting period, certain exclusions. So it's early days, but there definitely will be insurance claim activity and recoveries.
Right, okay. Just a question about how cyber policies are constructed. I mean, how are they constructed to deal with, I guess, cyber situations? And this wasn't a cyber situation, as we said. I mean, this was an IT failure.
Well, it is I mean, that's correct. It was a cyber incident, but it wasn't a malicious cyber incident.
Right.
So again, it's an evolving area, and certainly within the insurance industry, it's a newer form of coverage. And as I said, because even a cyber policy is relatively new on the scene, there really is no standard language. Mm-hmm. And so every one of these policies, similar to the contracts that we were just talking about, has to be looked at very closely to see what are the triggering events and what are the terms and conditions that are applied. But a standard cyber policy, you would expect to see both first-party coverage that would protect the policyholder for its own losses, and third-party coverage that would protect the policyholder if, as a result of the CrowdStrike event, they were sued or they had some liability as a result of inability to provide a service, inability to follow through on a contract or something like that. And while I think there will be first and third party claim activity, the majority of it is probably going to be in the first party area. So the key issues under the first party policy will be, number one, what's the insuring event that's defined in the policy? Is there cover for not only malicious acts, but is there also coverage for system failure? I think because, as we said earlier, the traditional thought about why do I need a cyber insurance policy is because some bad actor is going to try to get into our system and try to steal data, try to muck up the works. There are many cyber policies that would have cover for malicious acts, but maybe not have cover for systems failure. So first of all, in the CrowdStrike area, because it's clear there were no malicious acts, the policyholder is going to have had cover for systems failure. Then secondly, the policyholder will need to check the policy to determine what were the waiting periods. These first-party policies typically have a waiting period that actually prevents the insurer from having to pay for small losses. In a cyber policy, again, there's no standard language, but a waiting period could be 4 hours, could be 12 hours. I've seen some that are up to 48 hours. And the larger the business, the larger the policyholder, sometimes the larger the waiting period. There are also often sublimits and deductibles when it comes to business interruption. So I think a policyholder would need to look at that. Because this is early days and there have been there hasn't been a tremendous amount of activity out there, it's hard to, and by the way, there's been very little cyber insurance coverage litigation. So it's hard to project how insurers and policyholders or where they may find themselves in some disagreement about the language in a policy and what it's meant to, and what it was meant to cover and what it wasn't meant to cover. That being said, at least in the US, there's probably been 3 or 4 reported decisions now focusing on general standalone cyber policies. And the good news for policyholders is the courts so far have construed those policies pretty broadly. And so there's probably good reason for a policyholder to believe that a standalone cyber policy is going to respond in some way, shape, or form to this loss.
Right. I was going to ask you, Frank, I mean, given this is a relatively new type of policy, whether there would be litigation around interpretation that you could see possibly arising from it. I think you said, perhaps that would happen, but
21 years in the industry tells me there's no doubt there will be some litigation, especially when it comes to new and very unstandard language. So yeah, I'm sure there will be some. There always tends to be less litigation in first party. In fact, there's always much less litigation in first party cover than third party cover. I'm sure there will be, insurers will look closely at proofs of loss that are submitted by policyholders when it comes to economic loss, when it comes to a duty to mitigate, when it comes to the nature of the coverage and the nature of the economic losses that are submitted. It's never a completely smooth route, but this will be a good opportunity for the insurance entity to demonstrate to the commercial policyholder world the value of cyber coverage and why they need to consider not just malicious act coverage, but also systems failure coverage.
yeah, that's interesting. How about the other end of it, where an insurer is paid out? Do you see subrogated claims being brought by insurers against somebody like CrowdStrike?
No, I'm sure there will be. I'm sure there will be. When you have a particular or a limited number of probable sources when it comes to a loss, there's always subrogation. And I think the property and casualty insurance industry over the last several years has become much more, I think rightly so, much more aggressive when it comes to recovery, especially recovery in large events when it's obvious where the event started. So for sure there will be.
Right. Okay. Well, maybe looking just outside of specific cyber policies, are there any other potential policies that might be affected by this?
I think so. For some of the large entities publicly traded entities who are involved, I'm sure that they have put their D&O insurers on notice, and there will be some D&O claims, and I believe there's already some securities actions that have been filed as a result of the incident. I think there'll be a lot of smaller type claims that are filed under event cancellation or travel insurance. We heard a little bit about some E&O claims, and I'm sure there will be E&O claims that'll be filed for entities who weren't able to provide a service to their clients as a result of the event. The one place that I don't think there will be a tremendous amount of successful claim activity would be in what was called for a period of time the silent cyber coverage. For a period of years, as these cyber events were happening and the insurance industry was learning more about them, claims were made under standard property and casualty policies. But in the last probably 24 months or so, most of those standard policies have been endorsed with cyber exclusions. And so I don't think there will be as much of a concern about a silent cyber wave of claims, but there certainly will be focus on standalone cyber policies.
Okay, that's very helpful. Okay, Frank. Maybe one thing just to touch on is between the insurer and insured under these policies, what's the standard disputes clause look like? I mean, is it arbitration, litigation, is there mediation?
It's going to depend on where you are. I don't think there is a standard for dispute resolution. My guess would be in the United States and a lot of policies that have been issued in the US, there probably will be no dispute resolution clause. Although I would say that in the past 2 or 3 years, since I left the insurance industry, I've seen more primary insurance policies that have an arbitration clause than I saw in the years when I was working in the industry. And I'm not sure whether or not certain commercial insurers have decided that they prefer to pursue litigation against an insurer in an arbitration form as opposed to a court. But I would think there will probably be more policies that will be silent on ADR. And there'll be very few policies that will call for mandatory mediation.
Right.
Now, the fact of the matter is, especially in the United States, in almost every court, there tends to be mandatory mediation in the litigation context. But I don't think there will be many contractually mandated mediation clauses, in my opinion.
Yeah. And just generally on mediation and the view in the industry with respect to the use of it, as you say, you might be forced to use it at some point, but is it something that strategically the insurer also looks at the use of mediation and whether that might be useful earlier on?
I would hope so. Most every claim has a place where it can or should be, and there's a certain opportunity to resolve. And but the whole legal industry has evolved tremendously in the last 30 years when it comes to dispute resolution, and mediation is a very important tool, not only to relieve the burden on the courts, but just to get parties together quickly to responsibly resolve matters. So I would hope so.
Okay, very good, Frank. Thank you very much. That has been very interesting and useful. Well, then turning to the dispute resolution side of it, and we've got Mike Henley here, who's going to explore perhaps some of the solutions like mediation. And Mike is a lawyer and has been an accredited mediator since 1996. For 20 years, he was a partner and head of dispute resolution at an international law firm where his practice won the CEDAR, that's the Center for Effective Dispute Resolution just across the hall from us here, award for professional excellence in ADR on 3 occasions. Mike then joined the international management consulting firm, the PA Consulting Group, the one that Elliot Rose is with as well, as a partner, and later he joined the HSBC Group, the banking group, where he was managing director of HSBC Global Services. Over his career, he has worked with many organizations in many sectors to help them resolve commercial disputes, agree commercial deals, and to deliver change with a particular focus on technology. He has now established a practice as a mediator. So you've been a mediator a long time, Mike. I think much as myself, you used it in your corporate practice.
Absolutely.
So you were a user of the mediation services, now you are the mediator, so that's a slightly different role, but it helps to have been in the, in wearing the other shoes as well. So just looking at CrowdStrike here, Mike, how should we be thinking about CrowdStrike disputes in terms of their resolution? What would you advise?
Yeah, so again, thank you all for having me along. I think when the news broke about the CrowdStrike outage, the first thing that occurred to me was there's probably going to be quite a few claims and disputes, and that a lot of those are probably not going to be very straightforward. And listening to Elliot and Joanne and Frank talk, that's probably about right. The second thing which occurred to me was that it's probably going to be in the best interests of the parties involved in these disputes to think about trying to settle them at an early stage. And the reason that I say that is, there's a couple of reasons. First of all, when you look at it from the point of view of the customer, cyber security incidents and business interruption incidents tend to cause what I would describe as financial shocks. So they're sudden, unplanned losses which can have a big effect on revenues and cash flows. And for example, if we look at that airline that dare not speak its name, but I think we all know who it is, because it's out there, they work on a net operating margin of less than 7%. So the disruption doesn't have to run for many days before it starts to blow quite a big hole in your earnings, and that's a hole that needs to be funded and made good so far as you can as soon as possible. So I think it's going to be something worth thinking about from the point of view of customers, thinking about looking to resolve these disputes early on. Now that might suggest that actually time is on the defendant's side, because if the customers are looking to settle early, defendants might take the view, well, it might serve our purposes to delay, to elongate the cases with a view to negotiating a better result at a later stage. But I think as has already been touched upon, there are a number of features here which I think suggest it may well be in the defendant's best interests to think about early resolution. These tech companies, service providers, and the insurers all have brands which need to be protected and supported, and they have important relationships with customers that they need to preserve. And I mean, CrowdStrike get that big time. If you look at what they've done, they've gone on a massive charm offensive with their customer base. And I think in the future it could well turn out to be a really interesting case study in terms of corporate crisis management, the way that they've gone about that, because they're trying to get their customers to focus on the future and how it'll help them make sure this doesn't happen and distract them from what's gone before. So a really interesting approach that they've taken there. The other thing is that if you're an organisation that may be facing a high number of claims, and some of them might be, then if adopting a strategy of looking to settle the cases early is going to have quite an impact on the overall cost associated with these claims. So I think for those reasons, it's probably something worth thinking about if you're a customer or a defendant. Should we be thinking about trying to resolve these claims sooner rather than later, whether by mediation or other alternative process?
Right, yeah, that's very interesting. I think that also fits into what Frank was saying. In the insurance industry. You've got a new product like cyber insurance that you're trying to sell.
Yeah.
If you're now going to take a position with the insurance that you're not paying out, and you're going to argue about the wording of the policies, that's not going to help you to sell the policy in the future. So there is this dynamic that these companies have to deal with.
Absolutely.
Now, right? it and make that really a pragmatic business decision
Yeah.
as to how they're going to deal with it.
And just picking up on something that Frank said about, the progression of mediation and alternative processes, particularly in the States. I mean, as you all know, and I'm sure Joanna will know, we're seeing that in the UK. We always tend to be behind the US, but mediation is now compulsory in cases up to a value of £10,000, and there's been a recent case which has basically said, it's okay for the courts to tell the parties to go away and try and mediate the case. So we're moving much more to a situation of compulsory mediation in the UK, and if you're going to have to do it, then there's a good argument to say that you should be getting on with it as soon as possible, I would suggest, particularly in cases like this.
So just on that point, Mike, I mean, there's always been at least an argument that you hear from lawyers saying it's too early to mediate.
Yeah.
So what is the impact of early mediation as opposed to maybe waiting until there's more information developed?
Yeah, I mean, I think that's a great question. I mean, if you look at the life cycle of a dispute or the life cycle of litigation, the dynamics do change over time as the case proceeds. So I think there are differences between those dynamics as they apply later on and those which arise at an earlier stage. And I think I'd call out possibly three of those. So legal uncertainty, cognitive biases, and what you might describe as litigation fatigue. So if you look at legal uncertainty, as you said, before the case is fully developed, lawyers are worried that the clients they often believe that they'll build much better negotiation leverage if they take some time to articulate their case, if they can spend more time developing their case and getting it across, and also if they have time to attack the case of the other side and perhaps undermine the other side's confidence in their case. And that creates often a reluctance at an early stage to negotiate or to settle, because with some justification they can be worried that they're going to be giving value away. So that's one of the differences that you do see with early stage mediation. The other thing is cognitive biases, so those unconscious, illogical, psychological traits that most of us have, things like confirmation bias, which is this tendency we have to look for, focus on and recall information which suits the narrative we're trying to create and the case we're trying to build, and discount anything that doesn't fit that story. Or things like attribution bias, which is when problems occur, the tendency to blame other people, and in blaming those other people, attribute things as to what they're doing wrong to character defects or personality defects or defects in their professionalism or in their approach, without taking into account perhaps our own contribution or situational factors that may have had an effect. And those cognitive biases, in my experience, tend to be much more entrenched and active at an early stage in the dispute rather than later on, so they can constitute a much higher barrier to resolution. And then the third thing I'd call out is what might be described as litigation fatigue. Now, I'd like to claim or say that the cases that I mediate and which settle, it's all because of my amazing mediation skills, but a lot of it is due to the fact that, particularly when you're mediating later on, the parties have got a bit tired of being involved in litigation. Their priorities might have changed, they might have found other things that they want to spend their time and money on. They may get a bit tired of writing big checks to fund litigation, or they might just wake up one day and think, life's too short for this, I want to do something different. So litigation fatigue can be a really helpful dynamic in promoting settlement later on, whereas earlier on in the dispute, it's just not there to the same extent, so it's not helping as much as it otherwise be. So those are just two or three things that I call out as the differences between early stage mediation at a later stage.
Right. Now, with respect to CrowdStrike or situations like that, and you already, I think, alluded to it, there might be some advantage to trying to resolve these types of cases early on.
Yeah.
And so how would you see the use of early mediation in
Yeah.
that situation?
So I think you've got to think about, if you accept that mediating at an early stage is different, then you've got to think about, okay, so how do we address and manage those differences? Accepting that no two cases are the same. And I think it's a question not just for neutrals like you, Frank, and I, but it's also a question for the advisors as well. How do they think differently to help their clients in these sorts of situations? And I'd call out three things. So first of all, trying to foster a settlement mindset. Focusing on risk, I think, is an important one. And then the third thing I'd call out is working with ambiguity. So in terms of fostering a settlement mindset, how do you do that? And I think one of the things worth thinking about is, don't wait for the mediation meeting to start mediating. So use the time between the signature of the mediation agreement and the mediation meeting to get some work done between the mediator and the parties to really try and understand what the key issues are, what the key risks are, what the likely outcomes might be, what the commercial scenarios might be, so that you're going into the mediation meeting with that momentum, which I think helps to develop a positive settlement mindset. The next thing I'd suggest is thinking differently about mediation submissions and opening statements. So mediation submissions are usually prepared by the parties and exchanged before the mediation meeting takes place, but they're often little more than a restatement of the legal position. And I consider dispensing with those when you've got an early stage mediation, because the mere act of preparation and exchange can just serve to entrench those legal positions and also perhaps fuel some of those cognitive biases that I talked about earlier. So think about dispensing with the mediation submission and thinking about trying to reorientate the opening statements that are made at the beginning of the mediation meeting, trying to reorientate those more around towards the commercial issues and developing a dialogue between the parties as opposed to rehashing the legal arguments. So think differently about those. And then the final thing is, in terms of fostering a settlement mindset, I'd think about committing to a non-binding neutral evaluation in the mediation agreement. So I think we all know that if a mediation does not result in a settlement, the parties can, but they're not obliged to, but they can, invite the mediator to prepare a non-binding neutral evaluation where the mediator will come back and give them a view on the case, a view on where a likely settlement might lie. But baking that into the process right from the start means that the parties know that if the case doesn't settle through mediation, they're going to get a view from the mediator, which is probably going to narrow the room for manoeuvre that they're going to have in future negotiations. So it can create a positive impetus towards settling earlier rather than later. So those are the things I think about in terms of fostering a settlement mindset. The other thing in terms of addressing these differences I'd think about is focusing on risk. Now, in all these cases, the legal issues are going to be incredibly important. But focusing too much on the legal issues at an early stage in the mediation can create some problems in my experience, because at that early stage, the people involved, the lawyers and their clients, are going to be very wary about conceding any legal ground. A pure legal discussion can often just entrench positions, as we've talked about. And a lot of these disputes, including the CrowdStrike disputes, are going to be zero-sum disputes, win-lose disputes. And just looking at the legals can give you a very, very broad range of outcomes between a win outcome at one end and a lose outcome at the other. So it's not really particularly effective in trying to bring the parties together at an earlier stage. And so I find in my experience that actually with these early stage mediations and also later on, getting the parties to take those legal issues and then think about what the risks are that come out of those can be very helpful. So Joanne's very helpfully described what those issues might look like. So has there been a breach of contract? That might be the first one. Does force majeure apply? That might be the next one. Is the liability excluded or is the liability capped? So you've got 4 big high-level issues there, and you can sort of work out what the probability is of those occurring, and then what sort of outcomes do they produce. You can apply some values to those, and that starts to build a risk view, some risk-weighted values, which tend to give you a narrower spectrum on the settlement range. And it also, the whole discussion around how you create that risk view can often lead to a more pragmatic and commercial discussion, in my experience, between the parties. So I think about trying to focus a bit more on the risk side of the equation when you're looking at early stage mediation. And then my final point would be this point about working with ambiguity, because I think we all know that businesses make some big decisions, often without having, and usually without having perfect information and data. They have to trade things off, they have to make judgments, they have to think about what assumptions they have, sensible assumptions they have to make. And they make those decisions knowing that they're not perfect and that there are going to be some risks that they have to manage around that. And as we've discussed with early stage resolution, it can often be the case that you don't have the legal issues fully developed, you don't have all the evidence out there, you don't have all the information that you need. So being able to work with that ambiguity is very important. And the test for me is whether or not the parties can walk out of the mediation with the settlement and go back to their stakeholders with a credible story as to why they settled. Can they explain to their shareholders or their board, this is why we agreed to this in a credible way? And in my experience, if you are prepared to work a bit with ambiguity, you can do that. So I think accepting ambiguity, fostering the settlement mindset, and thinking about focusing risks are key things to think about when you're looking at a CrowdStrike dispute, or even looking generally at trying to resolve the case early on in the dispute.
Right. Well, just hearing what you said, Mike, but also, given your experience in various industries and in practice as well, would you advise a company then, whether you're a CrowdStrike or you're a customer of CrowdStrike, to actually put into a disputes clause a mediation provision, which in effect requires then fairly early mediation to take place before you can go on?
Yeah, and I think different to Frank's experience in the insurance industry, my experience in the IT industry, looking at IT license agreements, long-term strategic outsourcing arrangements, particularly with the long-term service provision arrangements, they will all have a dispute resolution schedule in them, which provides a whole escalation procedure, which ultimately will arrive at a point where the parties are expected to mediate, or depending on the nature of disputes, look at some sort of expert determination, because it's a highly technical issue. An expert determination may be a much better sort of dispute mechanism. But in my experience, in those sorts of arrangements, it's pretty commonplace.
Right. Yeah. Okay. That's very useful, Mike. Thank you. How about Joanne? In your experience, I mean, you are involved in drafting a lot of these contracts. would you put a mediation provision or a step clause in place?
Yeah, I mean, my experience really mirrors that of Mike's, particularly I think when you're moving into areas that are much more highly technical, you tend to see that the dispute resolution clauses get longer and longer. I mean, I was actually involved in an IT contract dispute last year where we ended up having a dispute over the terms of the dispute resolution mechanism. So that's taking it to the nth degree. But I think it's right in these sorts of situations to, and again, I think going back to that earlier point, we talked about where you're in an ecosystem and where you have got suppliers in the chain who are very integrated in your business, often trying to resolve an issue before it escalates too far is the best way to maintain that working relationship and enable the parties to continue their business as effectively as possible going forward.
Right, yeah. I mean, my own experience was that as well with our supply chain, given that often they were a highly skilled and also a supply chain that had to, in many cases, be pre-approved. It would take a long time to find other suppliers. So mediation clauses with that type of supplier are almost essential. I mean, you're not going to arbitrate with them when you have to continue working with them.
I think that's in where we are today. I think that's a critical point. I think you made this, Joanne, which is that a lot of organisations are locked into their service providers. You know, when a major bank puts goes to someone for a major ERP system in the cloud somewhere, going with someone else is not something you're going to do in the next month or so. Extracting yourself from these arrangements is very, very difficult indeed. So you've got to make them work. And you can't just make them work by bashing your suppliers, bashing the contract over your head of your suppliers. You've got to think about it in much more holistic and relationship-based way. And a lot of organisations do think like that.
Yeah, Frank?
I was going to say, just putting my former chief claims officer hat on, there's no doubt that one of the keys to early mediation is relationship.
Yeah.
And that's probably, in my mind, the premier motivating factor for a non-mandatory early mediation. It's parties that realize they have the mindset of embracing risk and ambiguity, but they also have the mindset of continuing a relationship.
Right.
So I just I thought what you articulated as far as the settlement mindset for early mediation was right on from my point of view.
Great, yeah. Well, I think we're drawing to a close. I don't see any questions here, but I wanted to give each of you an opportunity maybe to make another brief comment. Maybe what's a key takeaway from each of you in the way of advice for our participants. So maybe Elliot, starting with you, what's the key takeaway?
Thank you. I mean, probably two. I think the first thing is really understand your supply chain. We talked about in terms of the ways in which you can approach that if things go wrong, but do you really understand the supply chain? And there's so many clients we work with today, we do some analysis and they think their supply chain ends there, but actually if you look at it, it goes way, way back. Because they're reliant on third parties, fourth parties, fifth parties. And so it's really, you really need to understand how that service being provided is being glued together and understanding, because you can have all the remediation activity or arbitration or litigation, but it then happens, it's about being proactive about it. So it's being really proactive around that, understanding what's written there in the contracts. But I think I come back to the point about the operational resilience thing of testing people, process and technology, thinking through the way, look at the lessons learned from CrowdStrike, look at other incidents that have happened and try to think about how can things go wrong, and if this goes wrong, how do we recover from it, and understanding where the critical business services are. So, it's my point at my first question is about test and test again, do it on a regular basis, because things change and evolve as well. So, those would be my 2 points to take away.
Okay, thank you, Elliot. John?
I think mine would be doing a lessons learned approach to your legal contracts based on what we've seen from the CrowdStrike outage. I think if you're in the business function, speak to your legal team, find out if you had been impacted by CrowdStrike, assuming you haven't, what would the fallout have been? How would your company have been impacted? What could you have claimed? And take lessons learned from that and make sure that your legal teams are then feeding that into your contracts going forward. If you're already in the legal function, give some thought to your force majeure clauses, take a close look at those. Would they have bitten in this situation? Would you have wanted them to? Depending which side of the coin you're on, and just really reanalyze based on what we've learned from this experience and see what changes you might need to make going forward in your legal contracts.
Yeah, very helpful. Thank you, Joanne. Frank?
Mine would be, from an insurance perspective, to use the CrowdStrike incident as an affirmation that you have to look broadly when you're thinking about risk transfer for cyber risks. And as I said earlier, the traditional view that cyber risk was really just the malicious act is too narrow a view. And so from that standpoint, commercial policyholders should be focused on language of their insurance policies to make sure that they're broad enough to cover not only the malicious act, but also the operational failure, the system failure, which is obviously can wreak havoc within commercial businesses.
You must have a crystal ball, because we just had a question came in that you just answered with your final statement.
How about that?
So whoever sent in the question, you just had your answer there. Thank you. All right, Mike.
Yeah, so my final thought would be that, I would say this, wouldn't I? I think mediation is a very helpful business tool. And it's a good thing in its own right to do, just from the perspective of a business or organisation's own best interest. But just tying into something which Elliot was saying earlier, this focus that you're seeing at government level, at regulator level, around operational resilience, around critical infrastructure, the definition of which is getting wider and wider,
Right.
is absolutely critical these days. And businesses and organisations need to be able to not just run themselves efficiently, but they have to explain to regulators and other people outside their organisation how they work. And they're also going to have to explain what they're going to do when things go wrong. And when things go wrong, if they're not thinking in terms of how they preserve their relationships, how they use tools like mediation, etc., then I think regulators and others are going to start picking them up on that sort of thing. So that will be my final thought. I think mediation is a good thing. I think that's a truism. But I also think it's something that is now going to be expected not just by the courts, but by third parties like regulators.
Very good. Okay, well, that's a great place to end. I'd like to thank the panel again for coming today and sharing your wisdom. I think this is a critical topic, and it is one that was well covered here today, so thank you very much. I'd like to thank the participants who dialed in and who have persevered and who are still there for joining us today. Hopefully you did get something valuable out of it, and we hope that you go away and make yourselves more resilient. Thank you very much.
Thank you.
Thank you.
Thank you all.